Hello, and welcome to Ipsa Dixit, a podcast on legal scholarship. I'm your host, Brian L. Fry, Spears Gilbert Associate Professor of Law at the University of Kentucky College of Law. My guest is Dr. Aram Sinnreich, Associate Professor in the School of Communication at American University. We will discuss his new book, The Essential Guide to Intellectual Property, which is published by Yale University Press, as well as his work on the cultural history of intellectual property more generally. So welcome to the show, Aram.
Thanks so much, Brian.
Oh, it's great to have you on. I really enjoyed the book chapter you sent me, but I was wondering if before we talk kind of more specifically about that chapter, you could talk more generally about the book itself and sort of talk a little bit about the goal of the book and sort of how you approach intellectual property. In other words, kind of what do you think is essential to know about intellectual property, and how did you approach that in this book?
Sure. Great question. So I'm a communication scholar. That's what my doctorate's in. I have a master's in journalism. I am a working musician. So my perspective is totally based on a kind of cultural understanding of the role of law in society. I'm interested in copyright law, patent law, trademark law to the extent that they serve as some of the levers and parameters that shape social and cultural action. So I've done a lot of work in this subject over the years, mostly as a kind of critic of copyright maximalism and as somebody trying to figure out ways to reconcile the decidedly printing press era contours of copyright law with the kind of realities of digital cultural flows and networked cultural processes. So I'd done a lot of work on that subject. I'd written a book called The Piracy Crusade a couple of years ago that was kind of an in-depth critique of copyright maximalism and the rhetoric of piracy that often accompanies it. And I was frankly pretty sick of the subject. I felt like I'd said my piece and I wanted to move on. And I got an email from Yale University Press asking me if I wanted to write a course book on intellectual property. And, you know, for any academic, that's a kind of a flattering thing. Is, you know, a major press asks you to write their definitive book on a given subject. So I was kind of in a bind. I felt like on the one hand, like I'd be an idiot to say no, but on the other hand, like how many more books do we need that say, you know, copyrights are for this, patents are for that, trademarks are for this. Here's an example of how it works. So what I did was I kind of split the difference. And what I did was I proposed a book to them that was unlike every other IP book I've ever read, especially course books and textbooks, because what I wanted to do was to write a book about all the stuff that never gets told, the kind of hidden life of IP in the wild, or as I had originally titled the book, A People's Guide to Intellectual Property. And I pitched that book, and you know, I'd have a chapter on lobbying and campaign finance and like where these crazy cockamamie laws come from, and a chapter on international relations and intellectual property as a vector of soft power, and a chapter on cultural history, which I think is the one that we're going to be talking about today, you know, and looking at how IP has played this integral role in shaping visual and musical communication in the West over the past 500 years. And I fully expected Yale to say, this looks really interesting, thanks, but no thanks. We're actually just in the market for a textbook. And to my delight and surprise, they actually went for it. And they said, yeah, sure, we'll call your bluff. Why don't you write this book? So that's what I ended up writing. And all along, what I was really trying to do was, you know, as a musician, as a communication scholar, and as somebody who critiques the law, even though I'm not a lawyer or a law scholar, you know, it's always interesting to me how these different universes, and you can throw tech into the mix as well, they're so siloed from one another that not only do they approach the subject from totally different perspectives, but they actually use different sets of language. So they can't even have a productive conversation. So a lot of my work, but especially this book, is really geared towards trying to create something that integrates those different perspectives in a way that they can actually have a conversation with each other. So the technologists and policy people and artists can all be in the same room and figure out, whatever we want out of IP, whatever we hope that the law is going to do for us and for our professions and for our society, at least we can all have these common understandings about what its actual contours are, how it actually works, where it comes from, and where it's going.
Well, so in the context of the book, what do you think is missing? Like, what kind of big picture things do you think are missing in the sort of conventional wisdom about intellectual property? In other words, what are kind of, if you were to pick out a few really important things that consumers and maybe policymakers as well don't really understand or don't understand in a productive way, what would you point to?
Well, I teach a class on IP to communication students for the most part every year or two. And I can tell you, I see the misconceptions that people are acculturated with every time I have a fresh batch of students. And, some of these are honest mistakes that we make not being experts in the subject of law. And some of them are kind of the result of disinformation or propaganda from different interested parties who play a role in the IP ecology. One of them, I think, is the conflation of morality and law. So a lot of people who don't really know anything about copyright or patent law think that the job of the law is to enforce who's right or who's the true author of something, or to give somebody credit for something. And as obviously anybody who actually knows about IP law will instantly recognize that's not really what the law is for, right? And in the U.S. especially, the law is based on this constitutional mandate to kind of grant a limited monopoly to a creator or their assignee in exchange for making their work available to the public at large. And that's all in the interest of strengthening the public sphere and enriching the marketplace of ideas. And if we lose track of those two facts, number one, the kind of incentive-based constitutional dimension of it, geared towards strengthening the public sphere, and number two, the inherently mercantile nature of it, the notion that this is a monopoly, it's a market monopoly that is supported by the law and that is transferable and has nothing to do with who's right or who's true or who's good or who's bad, who's a real artist or who isn't. That distinction is so difficult to impress on people who don't have a background in the law. And I do a lot of work in the book to kind of tease those different themes out and to say, yes, of course it matters who we consider as a genuine artist and who isn't. And of course it matters who had an idea first. But those things are only marginally related to the way that the law actually works in practice and on paper. Another thing that people don't realize is that in practice, IP is often not really used for protection. A lot of our language about IP, copyright, patent, and